Glad you can join us for today's webinar titled Your Real Estate Legacy Self-Directed IRA Beneficiary Options. My name is Manzar Gaucher, and I'll be your presenter for this edition of our monthly webinar. I think today's topic is actually quite intriguing and one that is commonly overlooked and not given that much importance. So I hope that you find it to be informative and educational to you. Presentation will probably last about 30 to 45 minutes, after which we'll give you some time for some Q&A. So what I encourage you to do is type in your questions there at the bottom of the chat box at the screen, and we'll try to get to all of them, time permitting. So before we get started, basically I'd like to read out this disclaimer to you. The Entrust Group, Entrust, does not provide any investment advice or endorse any products. All the information and materials are for educational purposes only. All parties are encouraged to consult with their attorneys, accountants, and financial advisors before entering into any type of investment. So about the Entrust Group, a little bit about our firm, the Entrust Group here, for those of you who are unfamiliar with who we are and what we do. The Entrust Group is the leading provider of self-directed retirement plans. We work with individuals and small business owners who wish to invest in alternative investments, whether IRAs or 401k plans. We only provide self-directed plans. You make the investment choices. That's what makes us unique, is that we don't provide any investments to you or advice. What we provide is just the knowledge and tools for you to take control of your retirement assets. We've been in business for over 30 years, manage about $3 billion of our investor assets, again, by simply doing the record keeping for them, for their self-directed IRAs, and providing the education to them. Entrust is the only administrator with local offices nationwide, serving our clients in their own time region. We are the leaders in education, whether it's through our webinar series such as this, or our continuing education program for our professionals such as realtors, attorneys, or CPAs, or doing live local workshops and in-house presentations in our local offices. Our agenda for today, we'll start by kind of giving you a quick summary on how to invest in real estate with an IRA, since it's a very popular asset. We feel a lot of our clients are utilizing these days. And then get into our topic, which is how designating a beneficiary works, why it's important to designate a beneficiary for your IRA, how to properly notify those beneficiaries, what happens to your IRA in the case of a divorce or death, what you need to know and do if you are a beneficiary of an IRA account, then open it up for some Q&A for you. So let's get started here. How to invest in real estate with an IRA. By far, again, what I first mentioned is by far the most popular asset held in a self-directed IRA plan is real estate. So I wanted to kind of take a moment here to sort of going through the steps of investing in real estate with you, with your retirement funds, before getting into our main topic of IRA beneficiary options. So the first thing you want to be aware of is that you and your retirement plan are two separate entities. Therefore, if your IRA is purchasing the property, the title is held in the name of your retirement plan. So when you go out there and identify the property, the purchase contract must be made in the name of your retirement plan. If it's an IRA, the Entrust Group, for the benefit of, John Smith, IRA number 12345. And the earnest deposit, if any, is paid by IRA funds, not your personal funds. Entrust, as the administrator for your retirement plan, signs the purchase agreement, sends the earnest deposit, and coordinates with your escrow company to make sure all of your paperwork is titled and vested properly, again in the name of the Entrust group for the benefit of your IRA. We then fund your escrow, and now your IRA owns the property. At this point, all the rents go in and out of your IRA. All the rents go into your IRA tax-free or tax-deferred, depending on what type of retirement plan you have. Any expenses associated with the property are paid out of your IRA funds. It's really that simple. And I just want to give you kind of a quick overview on how you would invest in real estate with your retirement plan before we get into our main topic, which is designating beneficiaries and how it works. Properly designating your IRA beneficiaries is an integral part of your estate plan. A beneficiary can be any person or entity that you choose to receive the benefits. The most common beneficiary designations are spouses, children, grandchildren, or other direct family members. You can also name your living trust, for instance, or a charity as your beneficiary to the IRA, or make a combination of family members, trusts, or charities. A form must be filled out upon opening a retirement plan. So as part of any application is a beneficiary designate form that must be completed indicating who your beneficiaries are, who you listed as your beneficiaries. You must indicate whether the beneficiary is a primary or a contingent one. That's extremely important because your primary beneficiary may pass before you, and if you have not designated, for instance, a contingent beneficiary or beneficiaries, such as your children, there is a possibility that your estate becomes the default beneficiary. So it's very important to be aware of that. Again, why it's important to designate a beneficiary. For estate planning purposes, again, it's critical that you make appropriate beneficiary designations to make sure that your IRA assets pass to your beneficiaries according to your wishes, to your loved ones. By default, the money goes to the spouse. So for instance, if you establish an IRA and have listed married on the account application, and you have left for whatever reason, the beneficiary page blank, upon your death, your IRA funds will go straight to your spouse. Most IRA holders, however, will list their spouses anyway as primary beneficiaries, but you're not required to do so. For instance, if for estate planning purposes you decide to list your living trust or children as primary beneficiaries, and you are married, then the spouse must agree to that by signing what we call the spousal consent. Otherwise, the beneficiary designations are deemed invalid and the money just goes to the spouse by default. So again, just as important as it is to designate the primary beneficiary to your IRA, you want to make sure you designate the contingent beneficiaries. For instance, if you name your spouse as a primary and neglect to name your children as a contingent, right, the court follows the letter of law, and under the default provision of the IRS, distribution will be payable to the estate. How to properly notify your beneficiaries. As part of the process of establishing an IRA, you're required to complete and sign a beneficiary designation form. On that form, you would complete the basic information for the beneficiaries, such as their name, address, social security number, date of birth, relationship to you, and the percentages that you have allocated to them. So it's important that you notify your beneficiaries and let them know they are the potential heirs of your IRA funds. And just as important, I believe, is collecting the accurate information and filling out the beneficiary forms correctly. One thing to note here, that if you, let's say you have multiple IRAs, for instance, that each IRA will have its own beneficiary designation form to fill out. As always, though, please consult with your tax advisor or estate planner familiar with the laws in your state before proceeding. Let's go through a real-life example here. Actually, this live example was in the news, I think, a few months ago, and it really underlines the importance of properly designating your beneficiaries for your IRA. Mr. Leonard Smith here had 2 IRAs with a total value approximately $400,000. Before his death, he sat down with his financial advisors and attorneys to make sure his children receive his retirement funds upon his death. What he did however, was he filled out the IRA beneficiary form incorrectly, and instead of specifically listing the names of his children along with their designated percentages for each, he just simply wrote on the beneficiary form, "To be distributed pursuant to my will and testament." So remember what I previously mentioned, that by default money goes to the spouse. So in his case, his failure to complete the form correctly and indicating the name, specifically the names of the children and their designated percentages, invalidated the whole document, making his surviving wife of just 2 months the beneficiary by default, and not his children. His children fought the case, I believe, in court to try to recover the money, but the court awarded the $400,000 to their father's wife. Again, a real-life example and an unfortunate one for all of us to learn from, and to make sure that we properly, again, fill out and update our beneficiary forms. Tips to ensure your beneficiary receives the funds. Again, looking at Mr. Smith's unfortunate situation here, it is good to follow some straightforward tips to make sure your loved ones are protected and make sure that they receive the IRA beneficiaries that you've designated to them. 1, make sure that you have the most up-to-date forms. You should fill out a new form if you have had a birth or a death or a marriage or a divorce in your family. Any kind of change of status in your family, you should contact your administrator and fill out an up-to-date form. 2, keep several copies nearby, and if you can't find them, ask your financial institution or IRA administrator for a new one. Thirdly, set aside at least once a year again to update those forms. Or, as I already mentioned, do so once there's a change in the status in your family, for instance, a birth, a divorce, etc. And lastly, tell your family or heirs where you keep your important documents. Make them aware that they are the actual beneficiaries, or maybe provide them with the hard copies for their own files. So what happens to your IRA in the case of a divorce or death? Let's kind of briefly first discuss in the case of a divorce. And again, by no means are we tax advisors or estate planners. We are just giving you a quick overview and tips on this. To please consult your tax advisor and or estate planner moving forward. But in the case of a divorce, what happens to your IRA will really depend. It's going to depend and there are, each case is different. In some cases, nothing happens. It just stays with the IRA holder. In other cases, the divorce agreement would probably stipulate for your ex-spouse to receive a percentage of your IRA. It will be whatever. It could be 50%, whatever the separation or the divorce agreement states. In that scenario, the IRA administrator, or the Entrust group, for instance, would ask for a copy of the divorce decree or separation agreement, and that portion that is stated in that agreement of the IRA will be transferred to the ex-spouse's IRA. It's that simple. Now, there are two basic transfer methods for divorcing couples. One, which is what we call the direct transfer, I believe, which is the most common. This is where the IRA holder will direct the IRA plan administrator to transfer the necessary IRA assets, percentage associated with the ex-spouse, directly to a new or existing IRA in the name of the ex-spouse. So if he or she happened to already have an existing IRA, we'll just transfer that to them, or they would just set up a brand new IRA, and we would transfer the necessary IRA assets, which could be cash or in kind, depending, to the ex-spouse IRA. The other method, namely called renaming method, this is where the IRA holder transfers their portion of the assets they're entitled to keep to a new IRA. They set up a new IRA and renaming the existing IRA that they have with the ex-spouse's name. So those are kind of a couple ways that transfer methods for divorcing couples. Now, in the case of death, the beneficiary takes control of the IRA by simply presenting the deceased owner's original death certificate to the IRA plan administrator, and depending on the relationship of the inherited entity, will depend on how it's transferred over to them. And which takes us to our next topic here, which is what you need to know and do if you are a beneficiary of an IRA account. Now, before inheriting an IRA, again, you'll need to understand the tax consequences of doing so. And the results are very different depending on if you are inheriting from a spouse, a spousal IRA, or from a non-spouse. And again, to preface this, and the disclaimer is we are not tax advisors and we're not estate planning attorneys. We're just merely giving you a brief overview on the different types of inheritance, and please consult with your tax advisor on your specific situation. But in the case of inheriting from a spouse, for instance, there are a few choices, but the choices are simple, and there's much greater deal of flexibility on what you can do. Choices could include, one would be transferring the IRA over into your own IRA. So this way, you would just rename into, you take your ex-spouse's IRA and you just transfer over to yours. This will allow you to use your life expectancy for taking what we call required minimum distributions, and you will also be able to choose who will be the beneficiary after you pass. So just kind of stretching the IRA there. Or, second choice, you can elect to continue to treat the IRA as the deceased spouse's account. So it becomes an inherited IRA for you. If you're inheriting from a non-spouse, anyone, it could be your father, mother, uncle, grandparents, anyone other than a spouse, your options are, you have a little bit less flexibility because you cannot just transfer it over to you. You can, one, transfer the IRA into an inherited IRA, becomes a beneficiary IRA. You'll then be required to begin taking required minimum distributions, and the distributions will be calculated over your own life expectancy. Okay? Or you can simply, another choice, just cash out the IRA in full and pay the applicable taxes. Again, please note that we're merely outlining what you need to know and do if you are a beneficiary, and just providing you with an overview of the options available to you. And as in all of your financial considerations, please consult with your tax advisor on the best options for you, because one thing that we don't do is we don't give any sort of advice, whether it's tax, legal, investment advice, or what have you. So, establishing a real estate IRA. We talked at the beginning of the webinar on how to invest in real estate with IRA funds. So before I turn it over to any questions you may have, I wanted to kind of walk you through the process of establishing an IRA for the purpose of investing in real estate. And it's really as easy as 1, 2, 3. The first step you want to do is open up an Entrust account. And simply by completing our paperwork to include the beneficiary designate form that we just talked about, make sure it's completed accurately and so on. And in about 1 or 2 business days, we'll have your account opened and established. The second step would be to fund your account. And it could be funded in 1 of 3 ways. 1 would be to make a contribution, your annual contribution. 2 would be transfer your IRA, existing IRA, from your traditional financial institution into Entrust by simply completing our transfer forms. Or 3, rolling over from a previous 401k plan administrator that you, let's say you've left your job, separated from employment, it's sitting there dormant, you can move it over into a self-directed IRA. 2 or 3 are the most common. We rarely get an account to be open and making contributions, because your contribution limit, there are limits to how much you can contribute. So obviously, in order to look to invest in real estate, most likely you're either going to transfer another IRA that you have, or initiate a rollover from your previous employer. That either one typically takes about 7 to 10 business days, depending on where the money's coming from. Thirdly, you go out there and invest in the asset. You purchase the real estate as outlined before. Again, you go out there and identify the property you want to purchase, have the purchase agreement in the name of your retirement plan, the Entrust group, for the benefit of your name and IRA number. The purchase agreement comes to the IRA administrator, the Entrust group. We sign it after you've acknowledged as read and approved. We pay the earnest deposit out of your IRA funds, not your personal funds. And you direct us through a bidirection letter, an Entrust form telling us where you're purchasing, the name of the property, APN number, the address, is there a mortgage, all this information. Then we work with your escrow and title company to coordinate and make sure we have all the paperwork properly vested and titled in the name of your IRA. We fund escrow, we close escrow, and now your IRA owns the property. It's really that simple. Going forward, all your rental income will go back into your retirement plan, tax-free or tax-deferred, depending on what type of retirement plan you have. And then all the expenses, as I mentioned before, associated with the property, whether it's property taxes, maintenance, any of that will have to be paid out of your Entrust account. And that's really as simple as it gets, establishing a real estate IRA. I'm going to open up here for some questions. Let's see. Don't have many. I have one here. Stephen Young, can we loan money to our son's business from your IRA? Good question, Stephen. There are what we call disqualified persons, and the IRS prohibits you from doing any transactions with your retirement funds with disqualified persons. And a disqualified person is, 1, you. So for instance, you cannot loan your IRA funds to yourself, to your spouse, children, grandchildren, parents, grandparents, in-laws. So obviously your son here is a disqualified person, and by loaning money to your son's business from your IRA is a prohibited transaction, therefore disqualifies your retirement plan. So you do not want to do that. That also actually includes any entities that, so there's a business here that your son owns. If the business is owned by your son directly or indirectly, he owns 50% of or more, is still deemed a disqualified entity, and I would not deal with that business. So namely, any direct family members are deemed as disqualified persons. Ironically and interestingly, the IRS does not include siblings as disqualified persons. So you may deal with a sister or a brother all day long, as you're aware. You deal with them, and if let's say you're loaning the money to them at fair market value and all that. But I would use caution when I'm dealing with my siblings as well. So the best idea is to loan money to your IRA funds to non-disqualified persons, third-party family members. Yalin had a question here. Do you charge an annual fee, and how much? Our fees are, we have just a $50 setup fee when you set up your account. It's just a one-time fee. We have a funding fee depending on what you're looking to fund. If you're funding a real estate transaction, it's a $125 one-time fee. If it's a non-real estate transaction, if you're investing in an LLC, limited partnership, something of that nature, it's a one-time fee of $95. Then our annual record-keeping fees, we have two options. The most common is based on the number of assets that you have with us. So it's $295 per asset per year. So anything that's considered an asset with us, with the exception of cash. Another option would be if you're doing multiple investments with us, is to use option 2, which is based on the total value of your account, and it's a percentage basis point. It's a sliding scale depending on how much you have in your account. It's roughly about 50 basis points. Okay. Abu Shakir Shakir is asking, do we need to establish an LLC before investing? That's a good question, and the answer is you don't necessarily need to. There are some individuals that would rather just set up the LLC and have the IRA purchase membership interest in the LLC and become 100% owner of the LLC, and maybe go out there and purchase the properties through the LLC. That's totally fine. But are you required to do that? You don't need to. You might want to look at the advantages and disadvantages of doing through the LLC. Obviously, the biggest advantage would be the cost associated, the ease of funds. You're able to have checkbook control and be able to write checks right there and then. Another advantage could be the asset protection afforded to you by the LLC if it's properly structured. One of the big disadvantages would be the cost associated with setting up the LLC, and depending on what state, for instance in California, you have the annual franchise fee of almost $800. So things to look at and to see if that's something you might want to do. And also depends on what type of asset you're looking to purchase. For instance, if you're looking to buy multiple properties, you're looking to rehab those properties and then turn around and flip them, or you have multiple members, maybe that is a good idea to set up the LLC and have more control that way. If, for instance, you're looking to purchase just a piece of raw land, hold that piece of raw land in your IRA for future appreciation, it might not be a good idea to set up the LLC for that. So it's really up to you, but you are not required to establish the LLC. Brian had a question. Hi, can you give us an example of when one would name your family trust as a beneficiary? Again, that would be an estate planning question for your estate planning attorney. The beneficiary could be anyone or any entity. Again, you want to be aware of it does default to the spouse, as we mentioned before. A lot of times one would list their family trust as the primary, and then the spouse as a contingent. In this case, we would need spousal consent. Many times people would list the spouse as the primary and then the living trust as a contingent. But which way should be better? That's really a question you want to pose to your estate planning attorney. Yanlin has another question. For the raw land you just mentioned, do you know whether there are any annual property tax and other expenses besides your fees? Very good question. Obviously, any piece of property that you own, including raw land, will have property tax fees associated with it. What other fees associated with the raw land? I don't think there are any besides our fees. So that's why it's one of the most commonly used real estate types of investments, which is raw land, because all the associated fee involved is property taxes there. Looking at some other questions here. The questions, again, advantages of the LLC, I think we discussed that, ease of funds and the possible asset protection could be an advantage. Reg Grady had a question. Should the value of the self-directed IRA account appreciate substantially, does the annual distribution get recalculated? Yeah, your required minimum distribution is dependent on what the value of the account is, and we need a fair market value for your account at the end of each year. Yes. Enzo has a question here. As a real estate agent, could I write an offer to purchase a property as long as I don't collect a commission on it? The short answer is I wouldn't. Yeah, as long as you're not collecting any commissions, you should be fine, though. Jim, question. If I purchase a real estate IRA as a single man and am now married, can I designate my daughters as beneficiaries without spousal approval? And again, please consult with your estate planning attorney, but the answer is no. Okay, again, everything defaults to the spouse. And maybe the real life example that we had with Mrs. Smith there kind of outlines that. So you cannot designate your daughters as beneficiaries without getting your new wife's spousal approval on that. That's very important. But please consult with your estate planning attorney on that. Let's see if there's maybe one or two more questions here. So very good questions here, everyone. Let's see. Felicia said, please repeat what you said regarding naming trust as a primary Benny and spouse as contingent. Then by default, the spouse will receive the IRA. Again, anytime the spouse is not the primary beneficiary, we require the consent of the spouse. So you can list whomever as the beneficiary, primary, including your trust. But if you do not get the spousal consent, it's all invalidated. And it all by default goes to the spouse. So if you want to put your trust and or daughters or children or parents or brother as the primary and you are married, you would need to get spousal consent from your spouse on that. Otherwise, it will default to the spouse. So those were actually very good questions, a mixture of the topic that we talked about, beneficiaries. There were a couple of questions, and obviously everything kind of gravitated towards real estate and so on. As usual, we had some questions on that as well. Please, speaking of questions, look at the screen here has all my information, my email address, my direct phone number. Please feel free to call me or email me with any of your self-directed IRA questions. If you are local in Southern California, take advantage of that. My main office, I'm in Santa Monica. I also have an office in Mission Viejo in Orange County. be happy to meet with you at either offices to discuss your self-directed IRA needs. Please call me directly to set up an appointment on that. Or if you just have any simple questions, just email those questions to me. Again, I want to thank you all for joining us in today's webinar and hope to see you at one of our future webinar series. Thank you so much and have a great day.